let's kind of dig into why somebody might end up pleading guilty to something that they actually didn't do. Can we address that a little bit?
Well, I don't think I'd ever have someone plead guilty to something they didn't do. Let's start off with that as a fundamental start. If someone tells me they didn't do something, then I'm not going to have them plead guilty to it. And I don't care how bad the evidence looks. If you didn't commit this crime, then we'll find a way to prove your innocence. And so the issue is, you may be scared or you may have a lot of charges pending against you. But if you didn't commit the crime, we're not going to have you plead guilty to something you didn't do. That being said, it's really important for a client to be honest. A lot of times clients aren't honest with us and they will stand on the lie if they didn't commit a crime. Let's say they did commit a crime. The issue isn't whether you committed the crime or not, it's whether they have enough evidence to find you guilty of it. I mean, the government has to prove your guilt beyond a reasonable doubt, and there's attorney-client confidentiality. And so if you committed an offense, you're charged with it, and you actually did it, tell me. I need to know, as your defense attorney, everything we talked about is protected by attorney-client confidentiality. So I need to actually have the facts. I'm not an attorney who likes to bury their head in the sand. If you've committed the offense, doesn't mean you have to be guilty or not. We have many people have committed offenses and have gone to trial, and it's the government's burden to prove your guilt beyond a reasonable doubt. That's not our burden, and that's just plain the Constitution, whether you like that or not. So I'll start with that. Now, on the other hand, there's a time and a place for a guilty plea. Most people don't hire me to plead them guilty, but oftentimes we end up doing guilty pleas because sometimes it just makes sense. It's really a matter of risk tolerance and risk capacity. And what I mean by that is, what's your risk tolerance? How much risk can you tolerate to take something to trial? And what's your risk capacity? Let me give you an example of what I mean by those two things. Let's say you are highly risk tolerant, which means that you're okay to risk a not guilty verdict. If you want to fight for that not guilty verdict, and you're willing to risk maybe there's a 5-year sentence to confinement. You have a very high risk tolerance. But on the other side, let's say you have a family, you have 4 kids, you're about to hit retirement, and your risk capacity is very low, which means that you may personally have a high risk tolerance, but your ability to sustain the risk is very low. And that could be a lot of different reasons. You could be 2 years from retirement. You could have a new baby on the way. You can have children. And while you personally say, I'll take the risk, you can't afford if it goes bad. And so if you have someone with either a low risk tolerance or a low risk capacity, those are clients where it may make sense to talk about a plea agreement. And that's only if the case is strong, the government can prove the case against you, and you've actually committed the offense you're pleading guilty to. And if those are the situations, we can negotiate a plea agreement, and you may be facing 20 years in confinement, just for an example, where that will devastate your life and devastate your future. And perhaps we can get you a plea to a lesser included offense, maybe something that won't cause you to register as a sex offender, something that will cause you give you a much lower sentence, something that's manageable. Well, maybe you might not want to take the risk, and we can negotiate that, and it makes a lot more sense to do that. So the reality is, not everyone has the risk capacity and the risk tolerance to take a case to trial. I'm a trial lawyer. I'm a trial warrior. I would take every case to trial if I can, but I don't get to make the ultimate decision on that. Many times the clients just don't have the stomach or the ability to risk a case. And that's where we have to do a real analysis saying, how strong is the evidence against you? What's the likelihood of a conviction or an acquittal at trial? How do we think this is going to play out? And all of that factors into a conversation that we can have to see if it makes sense to negotiate a plea agreement or not, or just to take the case to trial.